King Darius, can I file for a green card if I was granted deferral of removal under CAT years ago? The answer is yes. You could always file for a green card, but in order to get to the green card process, you would have to reopen your removal case, because CAT is Convention Against Torture. You went through the removal case, and the immigration judge did not give you asylum, did not give you withholding or removal, but gave you Convention Against Torture, which is a rule that says that the government's never going to send you to another country to get killed or maimed by somebody in another country. So you showed that your life was in danger by going home, and that's the end of your deportation case. So now maybe you're married to a U.S. citizen, for example. You can file an I-130 visa petition, get that approved, but that doesn't give you a green card. That just says you're eligible for a green card, and you got to reopen your removal hearing, make a motion to reopen, show the judge that you're eligible for your green card, and then hopefully then adjust. So the answer is yes, with asterisk in parentheses. Kellyanne Optimistic Sybil asks, good afternoon, squad. I filed for my son in Jamaica in 2021 as an LPR. His process was documentarily completed last October and is waiting to be scheduled for an interview. I'm yet to hear anything since April 3rd after notification saying that they're still waiting. I became a citizen in March this year. Can you advise me how much longer to wait? Well, National Visa Center doesn't know you're a citizen. Take a photocopy of your naturalization, send it to the National Visa Center, and ask them to upgrade the case. And hopefully, if it's in Jamaica and you've been documentarily qualified, it's taking about 1 year from date of documentary qualification if you are a U.S. citizen. Nick, squad up. Question. Is there a pathway to get a green card through work by applying for EB3 with an employer sponsorship and file for adjustment of status via I-140 while having a pending asylum status? I already have received EAD. I currently have DT status. I've been inspected by CBP. I'm now in removal proceedings and master hearing data set. You cannot adjust your status once you're in removal hearing, unfortunately, through employment. If you entered the United States on a visa, applied for asylum while in legal status, and had not been put in removal yet, the answer would be yes. But since you're in removal, the answer, unfortunately, is no. Karen Whitaker, hi, Brad. What if you file for VAWA with an adjustment of status and you got a work permit but didn't get a prima facie letter? Is there a problem? And if you have a child under the age of 21, do they qualify? Your child under 21 does qualify. Well, it's not good news that you didn't get a prima facie, but it doesn't mean it's bad news. It's just not good news. Well, if you got prima facie, that means that you can get government benefits. And two, if you got prima facie, that means you've met the minimum thresholds of proving it was a bona fide marriage, proving there was abuse, and proving you have good moral character. So you didn't prove one of those 3 points to at least a minimum satisfactory level. So expect an RFE for a lot of evidence, and I would suggest getting a good attorney, getting ready for that RFE. But just because you didn't get a prima facie doesn't mean you're not going to get approved, but you need to turn things around starting now. That would be my best answer to you. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.